Welcome to the first in our series of videos providing practical insights on conducting corporate internal investigations. Over the series, you'll hear from specialists with years of experience in doing this work and handling the criminal, regulatory and wider fallout. In this session, we look at the crucial first few hours of handling an issue once it emerges. Decisions taken in those first few hours, when emotions and tensions may be high, can have a huge impact on the effectiveness of the investigation, but also on the exposure of the company and its people to wider risk. So what are the immediate considerations that need to be borne in mind? And what are the immediate steps when commencing an investigation?
Firstly, what are the allegations? You should analyse any report you may receive carefully. For example, does an allegation of wrongdoing by person A also carry with it an implication that others may have been involved or turned a blind eye? Secondly, what facts are immediately known or immediately obtainable? Immediately obtainable is important here. Most initial reports tend not to have a large amount of detail, but they generally will contain information which can easily be followed up. And the willingness to do that will be important as the case moves forward. A connected point really is, what can you do immediately to try to improve your knowledge of the circumstances? Some elements of this include the following types of questions. First of all, who may be involved and who may have the relevant knowledge or evidence? Next, is there anybody in management who should not be a part of any investigatory efforts because of a conflict of interest? Again, an important issue in many cases. Then consider the issue of documents. What documents exist that might be relevant to the issues? And if there's one point that I would emphasize and re-emphasize here, it would be the importance of documents to any investigation or later court proceeding or even media story. Nothing has the same impact as a smoking gun document, or indeed a document which might exculpate key people or the company. And it is much better to become aware of anything like this as early as possible. In the same way, any suggestion of a deliberate decision to suppress or hide or destroy documents would be extraordinarily damaging. As they always say, it's often the cover-up that is more harmful than the original infraction. Where are the documents and the relevant data stored? Where are the computer servers that might hold the data stored? Do you or the company have immediate rights of control or access those servers and that data within the UK? Can that data or the other documents be accessed or obtained without alerting others to the existence of the investigation? Tipping off, in other words, or even to the fact that someone is seeking to obtain those documents. Are there any legal restrictions, for example, under foreign law, if the material is stored overseas?
This is a key consideration to help the company prioritise and protect itself, but it's a step that's often not fully thought through to identify all of the relevant issues. The sorts of questions that need to be asked here are: what are the potential risks and exposures arising from the allegations? Are they legal, practical, reputational? And who and which group of companies face those risks? Could the company face liability, or is it just a victim? What about the individuals involved? How senior are they, and what ramifications does that have for the company? And are the risks criminal, civil, or regulatory, or all of the above? And what expectations of prosecutors and regulators need to be borne in mind when conducting the investigation? What are the most important issues to mitigate from the company's perspective, given that not every issue will always be possible to mitigate equally, and there may be a conflict between them? How sensitive are the issues? And does the company need the benefit of legal privilege when conducting the investigation? And what form of legal privilege is even available at the outset? And to what extent do the issues relate to actions overseas? What foreign advice might be needed? And what exposure could there be here for those overseas acts?
Once you've firmed up on what you know so far and identified the knowledge gaps that need to be plugged, this information can then be used as a basis for building a sound structure around the investigation. So what does this mean? A few things here will be key. First and foremost, it will be imperative to ascertain who should investigate. Should this be internal resource such as internal audit, legal or HR, or perhaps a specially formed investigation committee? Or is it sensible to appoint external investigators? This may be advisable where some of the subjects of the allegations are very senior, such that it will be difficult to demonstrate impartiality with an internal investigator. In addition to considering the optics of who investigates, having regard to potential bias or conflicts, the decision will be based on a number of other factors such as skill set and whether the investigation is to be conducted under legal privilege. If the allegations relate to serious sexual misconduct, then it's unlikely that internal audit would lead on the investigation, and it's more likely, for example, that HR and legal would take a leading role. In certain circumstances, particularly where the subject matter is highly specialised and where regulatory scrutiny is a factor, it may be that regulators would expect external support to be engaged in order to demonstrate that the issues are being taken seriously and that investigators have the appropriate level of expertise. There should be clear terms of reference for the investigator. This is a crucial document and fundamentally is a set of instructions laying out everything from the scope, methodology and indicative time frame through to the form of reporting. It's important that the terms of reference document is dynamic and is flexed in order to keep pace with the issues as they evolve. The terms of reference should also address the governance around the investigation. For example, who has authority to take or make decisions. Where an internal investigation committee has been put together, it will be important to set out the status of the committee and clearly document and demonstrate how it derives authority to carry out its functions. And last but not least, confidentiality will almost always be key when dealing with an investigation. Information should be shared on a need-to-know basis, and measures such as project names, code words, and document encryption should be encouraged to mitigate against the risk of information leaks.
First, think about the regulators. If you're in a regulated industry, it's likely you'll need to notify your regulators. In the financial services industry, for example, there are very wide-ranging obligations and expectations to notify the FCA and PRA. It is very important you get this engagement right at the start, as firms can face penalties and regulatory investigations for failures to notify, as well as for the underlying issues themselves. Think about insurers. Does the company have a professional indemnity insurance policy that might cover the costs? If the investigation concerns directors or senior managers or potential securities claims, you should also look at the D&O policy. Make sure you make the required notifications so there can't be any dispute later on with insurers. Other stakeholders might also need to be notified depending on the issues, like the auditors, or if the company is listed, the nomad or broker, as it might require an announcement to be made to the market. And it might also trigger other notification provisions, such as to bank lenders. Also, don't forget about leaks and if PR advisors need to be informed or a leak announcement to be prepared. Does the company have a data destruction policy? Any policy should be put on hold so you don't destroy any material that might be relevant to the allegations or the investigation. Criminal offences could be committed where evidence is destroyed. If there are concerns of improper conduct that has generated financial benefit, there could be money laundering issues, which if not dealt with properly can expose entirely innocent people to criminal risk. So consider carefully whether such payments can be stopped, delayed, or whether you need to make any reports. Think about restricting access of suspects to company systems and devices pending investigations. Much will depend on the issues, but these are the things you need to make sure you consider in those first critical 24 hours.